All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, Weekend Appointment, joined by Mark Virginis. Mark, how are you today?
Doing well on this scorching Saturday.
Oh, man, we've had some rain, let me tell you. Just in case anybody's listening to this down the road as a replay, this is taking place in June of 2010. So any advice we're giving you right now or any information is based on the current status of the law. And financial matters, tax rates, and strategies probably will have changed substantially in the next couple of years, given all the changes the economy's been going through. So keep that in mind in case you're listening to this down the road. Mark, I know you've got a little disclaimer you've got to give as well.
Yeah, my little disclaimer. First of all, the name of my firm is Mears. That's M as in Mark, IRUS, Mears Financial Partners. And here's my disclaimer. I'm a registered representative offering securities and investment advisory services to a Financial Network Investment Corporation. Member SIPC, Mears Financial Partners, and Financial Network are not affiliated.
Okay.
There you go.
We're out of the way. Got all our legal mumbo-jumbo out of the way. I know we decided we wanted to talk about estate and estate planning. And of course, one of the things that we talked about is who are the players or who do you bring to the table and how do you round up who you need. So we'll talk about that. But I guess I got a couple callers here, so we might as well see what they want, and we'll meet their needs first. Then we'll go back to our agenda, or maybe they're going to help us out.
Sounds good.
Karen, you're on with Carl and Mark on Weekend Appointment.
Hi, Carl. I'm not sure if this is an appropriate question, but I just was listening to the show and thought I'd call in. I recently had a friend who passed away, and she had an adopted daughter, and who is 16, and it was cancer, so it was very quick, and she forgot to change the beneficiary of her 401k, and it was still under her ex-husband. Does the daughter have any rights to that, or is there anything that they can do?
Well, Mark, what did we talk? We talked about this in preparation for the show as an important reminder, which we'll talk about again later. But what do you think?
Yeah, I mean, unfortunately, Carl and I both had actual client experiences with this. Contract, I'm sure Carl will echo this, contract supersedes the will. That 401k provider is going to pay those monies to the ex-husband.
Okay.
In the 401k company is going to say, how did I know? That was her wishes. That was her wishes. She would have changed it. I've had clients where they did get divorced and they remarried and they passed away. And I had one where it's like $600,000 was going to the ex-wife. The current wife's like, he meant for me to have that. How did I know?
Right, and we've seen this problem again and again. In fact, I can think of an estate I'm involved in. Where there's multiple siblings, and one of the siblings got the whole retirement because mom and dad only put one of the siblings on the retirement because at one point they were asked to fill something out, years and years ago, and they threw down one name thinking they were going to go back and change it someday. At least that's the best explanation anybody has.
Yeah, the daughter who didn't get anything, is that from the first marriage or that's from the second marriage?
She wasn't remarried. She was only married once, and this girl was adopted.
But that father was not the ex-husband's not the father of this daughter.
Correct.
I'm thinking, Carl, maybe disclaiming or something like that. But that's that's more going to be a legal matter for you.
Yeah, I mean, he could. I mean, if he's let me put it to you this way: nobody's going to be surprised if he just keeps the money.
Right.
On the other hand, if he feels some moral obligation, he could disclaim. And if he disclaimed it, then it would fall to her estate, and then it would fall to her daughter.
Okay.
It would become a taxable estate asset, so it would get the 4.5% lineal descendant tax rate in Pennsylvania. But so
be subject to probate as well.
So yeah, absolutely, Karen. I think your question now, and I really appreciate it because it's perfect for what Mark and I are trying to do here, which is to talk about the things you have to prepare for, and why it's never too soon to kind of get these ducks in a row.
Right.
Because, if we all knew the time and date of our death, I know what my credit cards would look like the day before I died.
Right.
Right. And I will say this as a good plug for Carl as well as for any other lawyer. out there that if someone has, and someone's listening to this, and they have issues where, they've seen their doctor, if they know the time is coming, and a good attorney who drafts that will, as opposed to going to Staples or some kind of office store and doing the will yourself or going online and doing it yourself, a good attorney is going to have like a checklist for you. And I guarantee you one of the checklist items is, are all your beneficiary designations on your retirement accounts, this account, that, are they all up to date? And that's a good housekeeping issue.
I would have thought an employer, when she changed her beneficiary for her life insurance policies, that they would have maybe prompted her, asked her at least if she was going to change that as well.
Yeah, you would hope the employers would do that, although strictly it's not their duty. So it's more of a, if they do, great. If they don't, they don't.
Right, or if you do it offline, you wouldn't really have a conversation. So
right. Well, Karen, thank you very much for your question. It is a good one, and hopefully somebody will learn from this.
Thank you, Karen.
Thank you.
All right, take care. Well, Mark, that's exactly why we're doing this.
Exactly. I mean, you'd be so. And it's almost like the shoemaker's kids is walking around with no shoes. I mean, you'd be surprised how many people in the financial world or legal world or just in the professional world you would think they would know to do this, and it does creep up on you. It's one of those things you forget. It's like people who never open their 401k statement. They just, it's there. I'm making contributions every week. I don't have to worry about it. But they never did the housekeeping on it and said, maybe they had kids that were born. When they started the job, they didn't have any kids. Well, now they have 3 kids. Well, they didn't go and change the beneficiary designation to say, if my wife not living, give it to somebody else. So now you just said that, money will be paid to the estate. It'll be probatable, maybe even taxable and held up and so forth. Eventually, the kids will get the money.
And subject to creditors, though. So,
there you go.
Because we had a caller earlier. I don't know if you were listening earlier this afternoon, but we had a caller, who's saying, what about my credit card debts versus my life insurance policies? Does my wife take that money and pay them? And the short answer is maybe, maybe not.
Right.
But if the money travels outside the estate, at least it's not going to be squarely netted against the debts of the estate, let alone taxed. Whereas if you let it lapse into the probate situation, we have to net it against all your expenses.
There you go.
Let's see here. We got another caller. Let's see. Lewis, you're on Weekend Appointment with Carl Rominger and Mark Virginis.
Hi, Carl. I had, a comment about the will situation that the lady called in about the second marriage. I write irrevocable wills all the time, usually for parents of second marriages who are worried about the same issue that she was involved with. And, I bring them in and have both of them sign irrevocable wills with consideration going to both, upon both having to sign at the same time and both being irrevocable and having them locked in upon either or's death. Now, I know it wouldn't do anything for the property if it's titled jointly.
Right.
But any other asset, it would be irrevocable unless both parties have to come in and change it at the same time. What about doing something like that?
Yeah, I think that's a viable strategy. But it sounded like in that case the husband didn't sound too enthused.
No.
It didn't sound like...
I find that a lot with second marriages because they've been through it the first time and probably been written out the last time, and they don't want the girlfriend or the husband or next spouse, their kids getting the assets they've accumulated over their lifetime. So I usually tell them, make it irrevocable. And now you're locking yourself in at the same time as he is, but at least it gives you some peace of mind that if you die, he can't go and give everything to the girlfriend or his kids and lock your kids out.
No, I like that. I think that would have been a good answer, particularly if you have a couple that sees each other or is going to mutually cooperate like that.
Carl, my little 2 cents here, because I heard that caller on your show earlier. The first thing that came to mind for me was Q-tip trust. The wife can just, at her death, put into a trust which she will let her current husband use for his health and well-being while he's alive, but at his death, everything in that trust would spill off to the daughter. That's what came to mind for me, because especially if they really want something going to their kids from a first marriage or a true linear descendant. I like trust because that's contract. When I hear wills, I just think set of directions, and I like contracts superseding directions all the time. I mean, I just think it's like having barbed wire around what you really truly want to give, and that's we live in a litigious society, and I just think it's cleaner that way. That's just my own 2 cents.
I agree with that. I mean, I think when they come to me, usually it's how can we do this now without setting up trust and trying to take the next step. And the first step is, well, if you just want to do it quick and clean, irrevocable wills are the way to do it. But I think a trust is more of a bedrock contract.
Right. I agree with that 100%, Louis. Louis, we're going to take a break here. I appreciate your call, and thank you very much for the insight.
You're welcome. Bye-bye.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Hey, we're back. Carl Rominger here with Mark Virginis and answering your legal questions here on the bonus edition. Mark, we were just talking in the break. We had some great calls in the first segment, and I guess we'll take Lance here and see where it goes. Lance.
Hi, Carl.
Hey, how are you?
I'm doing fine. My question for you today is there now or will there soon be a federal inheritance tax?
Great question for Carl. Go ahead, Carl.
Well, let me tell you something. The government needs money. The government needs a lot of money. In fact, they've spent so much money that they have spent more money than they have. How many trillions of dollars more, Kurt? Do you know?
About 14 trillion, something like that.
Okay, yeah. So what's my guess? My best guess is there's going to be one, and it's going to be punitive. That's my best guess. And Lance, I'm not completely kidding around either. I mean, I suspect that they will instate some kind of inheritance tax because they're looking for money anywhere they can. I also wouldn't be surprised if we see Pennsylvania consider upping their inheritance tax at some point. I mean, they haven't talked about that. I haven't heard any rumblings about it, but it's a great place to knock a couple percentage points, and really most of the public isn't going to complain.
And the state tax is, 4% now?
4.5% to lineal. 15% to anybody who's not a lineal descendant, and 0% between spouses. But as I always like to point out, there's a reason why it's a 0% rate, because that seems to anticipate that someday they might increase it.
Okay, if you had to give your best guess on the federal inheritance tax, would there be like a minimum amount to inherit and to be paying on? I mean, suppose the estate is worth $1 million and there are 3 or 4.
Mark, what were the numbers back when we just finished up here?
Well, 2009, we were able to pass $3.5 million each, so a married couple could pass $7 million. Right now, the Senate just passed legislation to invoke 2009's rate, $3.5 million, for 2011. The House hasn't seen that bill yet, nor have they ruled on that, because if we do nothing, in 2011, we'll go back to the $1 million allowable transfer, which, based on 08 and certainly so far this year's stock market, that may not be too bad. But really, $3.5 million, $7 million. A lot of folks can pass significant wealth for $7 million if that's what they enact for 2011. But as Carl said, government needs money. And going back to the Spanish-American War, in this, it wasn't called federal state tax back then, but basically we've had and repealed federal state tax 7 times in our nation's history. And if you look at when it happened, it seemed like it was enacted to pay for a war, almost exclusively. And you can say we're in a war on terrorism, war on deficits, what have you.
War on oil?
War on oil.
North Korea, maybe?
Yes, I mean, right now, the country is looking for money, and no one will turn their nose up at taxing the rich. I mean, they're an easy target because most people don't have $7 million.
Right.
So it'll be an easy grab. But again, if we do nothing, if they sit on their hands on this, they do nothing regarding this tax, we go back to how it was in 2001, which will be a $1 million exemption apiece.
And so, Mark, let's assume that we are headed back that way. What am I going to need to do to try to pass wealth on above that $1 million cap?
Well, we can certainly look at giving it to somebody now. There's what they call gifting strategies. Right now, we're allowed to give $13,000 per person to as many people as we want. So Mom, let's say she wanted to give my family money. I have 2 children and my wife. So my mom can give each of us $13,000, as well as my father can give each of us $13,000. So there's a significant chunk of money that she can pass along to us. Other strategies are, if you do some pre-planning and do some what-if scenarios, and your health allows it, you can possibly purchase life insurance for pennies on the dollar, which that's what life insurance is, discounted dollars, and you can actually provide cash at your death to either take care of estate taxes as opposed to forcing the sale of a home through fire sale, selling stocks and bonds, maybe not in a good market, and what have you, or collectibles. You just actually provide the cash so your heirs can go ahead and hang on to those assets and maybe sell them when the market returns or what have you. But life insurance is often overlooked, often downplayed, but it could be a very unique estate planning tool, especially for husbands and wives, because husbands and wives can buy something called survivorship or second-to-die insurance, much less expensive than 2 separate policies because it's one policy with 2 lives on it, usually husband and wife, so the insurance company doesn't have to pay a death benefit until the second person passes. So I got 2 mortality tables as opposed to 1. So usually, and then we probably would get Carl involved to say, hey, Carl, how should we own that policy? And perhaps you want to speak to that, Carl.
Well, I mean, who wants to own that policy? And I'm not sure. You tell me where we're headed with that, Mark. I mean,
I'm thinking, because remember, your estate is everything you own. So if you own that policy, if it's my wife and I, we own that policy, and let's say it's $1 million, that's $1 million includable in our gross estate.
Right, but if it's owned by your children.
If it's owned by your children, so you have 2 kids, you only need 2 signatures on that policy. Your kids can own it, but again, then that's part of their marital estate if they should get married, and if there's cash value in that policy, that's an asset, creditors and so forth. What I would like to see is going to someone like Carl and have him do an irrevocable life insurance trust. We put the policy in the trust. The beneficiary of the policy is the trust for the benefit of my estate. So, for example, I gift the premium into the trust. The trust turns around and writes a check to John Hancock, Transamerica, whoever. Policy's paid for upon my wife and I's death. The $1 million gets paid to the trust, and because I met with Carl several years earlier, I said, hey, Carl, when the money comes in, this is how I want the money distributed.
Right, and then the trust controls that.
You got it. And it's outside the estate. Uncle Sam's none the wiser because we did everything by the book. Everything was allowable by the IRS. Everybody's happy. My kids are real happy, and I'm smiling in the grave here because I was able to pass my estate intact.
So Lance, are we helping you here?
Yeah, but I have a couple of other related questions to that. I couldn't quite hear everything Mark was saying. If there's an estate of about $1 million, would the federal inheritance tax be on the $1 million, or would it be if there are like 4 siblings and each got $250,000? Would it be on the $250,000? Or
if it's at $1 million, let's say, and above, then the first $1 million is going to pass tax free for federal estate purposes.
First $1 million passes tax free.
Mm-hmm.
You would think anyway, right?
Yeah, if under the current, as what we're going back to, yes.
Okay, and what would the percentage be?
Well, what is the federal estate tax percentage? I think it goes up all the way up to 40 or more percent.
Oh my, isn't it
yeah,
something?
up to 55%. Up to 55% eventually. Let me see here. It's going to start. It's going to be an escalator. It's going to start somewhere in the area of 45%, and it's going to quickly go up to 55%.
Yeah. That's what I thought, started around 45%.
So if you have like a $4 million estate, you could be looking at the first $1 million free, and then after that paying 55%?
Yeah.
Wow. Yeah.
I guess that will raise revenue, won't it?
Well, and the federal estate tax has always been very punitive in that respect, so that's the problem. Now, there's also some things you can do with spousal exemptions. Correct me if I'm wrong, Mark. There's a few other strategies out there.
Now, Mark also mentioned gifting. Is there like a time limit on that? I mean, does it have to be like 5 years before?
Well, the short answer is no, not for estate tax purposes.
Not for state tax. Okay.
Estate tax, yeah, no, not for that purpose. Now we might, if you start gifting money while you're in the nursing home, Medicare might have a problem with that.
Okay, yeah. And then did I understand correctly, or did I misunderstand? Would it be like the children they could gift to, plus the children's spouses?
Right.
Okay, so if it's $13 a person, it could be $26,000 or $13,000 each person. It could be like $26,000 per couple.
Yeah, and if they have 2 kids, then you can get up to $52,000. And if you have 2 spouses doing it, you're at $104,000.
Wow.
And so you do that over 5 years, and now you've transferred $500,000 tax free.
Yeah.
The only thing that heads up there, Lance, is when you gift, let's say you gift shares of stock.
Mm-hmm.
Just to keep it simple. You bought Walmart stock, pick a company at $10 a share. It's now worth $100. Just I'm being fictitious here. It's now worth $100. You die and leave that stock to your kids. Your kids get that with what's called a step-up in basis. It's like you paid $100 for it. So there's no tax. There's going to be no capital gain on that. Right. When they say, if you gift that, then they get your cost basis, because they get to use that money now or that stock now.
Yeah.
So it's like they paid $10 a share.
Yeah.
That stock.
So that can change.
And then also, too, I'm sure Carl's will talk about this, too. You give things down to your son who might be trying to put 2 kids through college. You might have screwed up his financial aid for those kids. Because now he's got more money in the bank, more money in investments and so forth, that it might have just, I might say, it might have just muddied the waters.
I got to go to break here, Mark. So, Lance.
You answered my question very well, gentlemen. I appreciate your time.
Thank you, Lance.
Thank you. Bye.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
All right, we're back. Carl Rominger here with Mark Virginis. By the way, Mark, if one of the listeners wanted to get a hold of you, how would they do that?
There's a couple different ways. They can log on to my website, which is Mirus, M as in Mark, IRUS, Mirus Financial Partners, and partners is plural, .com, or they can just simply give me a call on the 717 area code 509-4521, 509-4521.
All right. And of course, if they want to get a hold of me or they want to find the information on you, they can always go to weekendappointment.com. I've got you listed as a friend of the show, and I've got my phone number tattooed all over that website.
Good.
Let's see here. John, you're on with Carl Rominger and Mark Virginis.
Carl?
Yes.
Hey, I don't think you were on break. We just heard about your brother in the golf.
Yeah.
Anyway, I wanted to know that whether or not I can leave my Social Security to, after I die, to anybody. Does it have to be my wife?
Well, your Social Security, your wife will get a benefit after you die, which is its own benefit. In other words, your Social Security terminates on your death.
Yeah.
Your wife has a survivor's right, or potentially has a survivor's interest in your Social Security. And so she would then make her own claim for Social Security, if that makes sense. So you don't really leave a benefit. Am I explaining that right, Mark?
Yeah, you're right there. So, for example, let's say your wife has her own Social Security. That's just simple. Yours is $2,000 a month. Hers is $1,000 a month. You pass away. She continues to get her $1,000 because she's alive. But the benefit would basically bring her up to what yours would have been. So she would get a death benefit, if you will, of $1,000 a month. So her $1,000 plus your death benefit $1,000, she gets back up to the $2,000. So she would still have her $2,000 a month. It's kind of screwy how the government does it, but Carl's right. It's exactly how he explained it.
Is that helpful, John?
Well, yeah, but I'm just wondering how much of a wife does she really have to be? I mean, do we have to go to the Justice of the Peace and get a license?
You better be married.
Okay.
Yeah.
Okay, I'd rather leave it to her than Uncle Sam.
Understand.
Okay, thank you.
All right, John, thanks.
Bye.
Yeah, I think, I guess it sounds like he needs to get married.
Well, that's a good question because, I mean, it comes into play, too, for long-term care planning. I mean, people do that as well to hopefully pass a state, and so nursing homes don't get all of the money. And, I mean, there's people get married for different reasons, not just for love.
Now, you were telling me something earlier about you've accumulated or you've compiled a list of people who lost a lot of money.
Yes.
Explain that to me.
Well, you look. Everyone thinks, when they hear someone famous, like for example, J.P. Morgan. When he passed away, he had a gross estate of a little bit over $17 million. When it was all said and done, he wound up only leaving 5.2. He had a 69% reduction, a shrinkage in his estate. You would have thought he would have did some sound estate planning or would have included some foundations or charities or different things, but he did not. Another big one, and I use these next two folks, John D. Rockefeller Sr., he passed away with almost $27 million, but after settlement costs, he only had 9.7. He has 64% shrinkage. Compare that to his son, John D. Rockefeller Jr., who had a gross estate of $160 million, but only lost 16% at his death. And he still passed $135.6 million. So you got to ask yourself, what did Junior know that Senior didn't? And one of the big deals that Junior did was most of his estate went to the Rockefeller Brothers Fund, Incorporated. He actually utilized foundations and charities to actually pass his wealth on for the next generation and so forth. So there are strategies that one can do. I mean, Elvis Presley had $10 million. His estate settlement cost $7.3. The net effect was almost 2.8 or 73% shrinkage. Now, some people in the know would say, well, Graceland,
right.
My gosh, I mean, isn't his estate making money? Well, in some cases they had to. They had to start commercializing the king because they had a ton of costs associated with his estate, and if you wanted his heirs to really remain a certain lifestyle, some would argue that's probably why they commercialize as much as they have been. So
it's interesting. So I guess to get back on track for what you and I want to talk about, we were going to talk about, and I think I'll skip up here just a little bit, just when you want to start planning your estate. One of the things I think you need to do, and this was highlighted by some of the callers, is gather up who you need. Obviously your spouse should be part of the conversation if you're going to be effective in these strategies.
Yeah, your spouse, children, to the extent you want them there. And
of course
their spouses, and that's a personal decision as well.
Right, and of course the other thing we talked about was that little rub of if you are going to use your kids as one of your strategies to start divesting wealth to preserve it for them, it's good to give them a little heads up. They don't want to wake up and find out that you did put $115,000 in an account or even $10,000 in an account in the name of a grandchild while they're out applying for financial aid.
Exactly. Or, they might be destitute right now. They might be being chased by the mortgage company to get out of their house. Who knows? They might be subject to creditors. So you really want to get those folks involved because you never know what kind of mess or, I would say, good financial status that they're in right now. So making these people a partner are good. Every client I've ever come upon has said, well, we're going to leave my daughter-in-law or son-in-law out of this. I just want my kids here. Thanksgiving and Christmas are perfect times to bring this up. It's not that we're talking about death. We're really doing some financial planning, albeit for later in life or what have you. It's an easier way to get all the players involved. Kids do come home for those holidays and what have you, so it's always a nice time to maybe broach this subject with them.
And so I guess we'd agree that to the extent you want to utilize people as part of your plan, you've got to involve them.
I would agree, and also too, if you have a financial advisor you use, or and be very wary if your current financial advisor has never brought any of this kind of stuff up to you. It's a staple of financial planning, but maybe they just don't know enough to bring this kind of stuff up. We go to specialists all the time in the medical field, eyes, or nose, ears, and throat doctor, or a cardiologist, or what, different practicing doctors. Same thing goes for the legal community and the financial community. They're great investment advisors, but when it comes to planning or estate planning, that's not what they do. So you may just need a different set of eyes, and that's why Carl and I are doing this show. So hopefully, folks out there see that we have the know-how. If they're interested in pursuing this field, they can get a hold of us.
The other thing we want to talk about is like the necessary documents, and of course that includes a will. And you should have a solid will that addresses who it is you care and love about, but also addresses what you're going to do with the residual portions of your estate. But I think from talking to you, Mark, one of the things that people should pick up on is the will is sort of a set of instructions, and if there's ways to handle things without letting it lapse into probate, that sometimes is a firmer and better way to handle things.
Right, because when I talk to my clients, the cost of probate doesn't scare me personally. It's more the public aspect of it. I mean, I'm sure you could tell folks how when a will's done, like how you take it to the prothonotary and how it goes through the probate process, it becomes public.
Oh, yeah.
And the last thing you want is, okay, you left your daughter $50,000 CD. No offense to anybody out there, but every speedboat salesman and aluminum siding salesman who buys lists of names just found out that your daughter's getting $50,000.
Right.
That's who they're at telemarket.
And people, if you don't think they check this stuff, trust me, there are people combing the courthouses. I had a friend when we were in college. She used to get 25 cents for every name she could take off of a new deed. She'd go up and pick out new deeds for people that just bought houses so they could sell it to marketing lists of people who just bought a house.
Exactly. I mean, and we do so much during our lifetime by, all these credit card ads that come in, or we guard our Social Security number with guns and armor. We make sure no one's, we have caller IDs, see who's calling us. We do everything we possibly can to make sure our information is safe. But here, we don't take the necessary steps that when we pass away, everything can become public. And that just blows me away.
And of course, if you handle things through trusts and other types of vehicles, life insurance vehicles, things like that, a lot of that's going to happen privately because those are going to be private contracts between the trusts and the individuals.
That's correct. That's where Carl's knowledge is key, and then for folks who have financial investments like 401ks, IRAs, 403bs, or brokerage accounts, you can do transfer on debt. You can do different things with ownership of assets. You just need to be willing to pick up the phone and spend some time with professionals just to make sure you're getting good advice. And quite frankly, I mean, at that time of death, your family and friends are going through a very, very severe emotional time. The last thing they want is a bunch of sharks swimming around the tank, so to speak, and no one's really going to make a financial decision because they're not going to have the wherewithal. It's going to be a very emotional time.
You're listening to Weekend Appointment with Carl Rominger and Mark Virginis. I'll see you after the break.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Oh, Carl Rominger here with Mark Virginis answering questions for folks and talking about wills and estates and estate planning. Mark, thanks for being with us today.
Well, thanks for having me, Carl.
Hey, Mark, we kind of, when we talked about this, putting this together, you and I carefully laid out all the topics we could talk about, and obviously we haven't been able to hit all the points we thought maybe we could, but we had some great questions. But I guess I wanted to go back and just backtrack a little bit to powers of attorney and living wills. A lot of times when people come in to see me, I get very few people. People do come to me for powers of attorney once in a while, but basically it's, mom's in the hospital, we need a power of attorney, or, there's a discrete issue, we need a power of attorney. I'm going to be out of town and I need my wife to be able to transact business while I'm in Iraq, whatever it might be. Or I get, I need a living will because I'm about to die and I just got diagnosed and I have to run out to the hospital or somewhere to do it. But most of the time, people don't just are sitting around saying, I'm planning ahead for the future, so I better go get a living will or a power of attorney. It comes up mostly when people come to see me about a traditional will, and I say, have you thought about these things? And they always say, yes, I have. I've always wondered about them. So I'll take a moment. A power of attorney is a document that allows you to give another person official legal authority to transact business on your behalf. And it can be very broad or it can be very narrow. It could be limited to one item or every aspect of your financial life. And it's a full power of substitution. And it's usually a durable power of attorney, meaning that if you were incapacitated but not dead for some reason, it would still be able to be used. A non-durable power of attorney, and any power of attorney that doesn't have the word durable in it is considered non-durable, lapses at death or incompetency. All powers of attorney lapse at death, and that's when the will would take over. So power of attorney fills that gap from the time of when somebody becomes either unable or unwilling to handle their own affairs or incapacitated. You can step in. So I always recommend that husbands and wives who are doing reciprocal wills, wills that leave everything to each other and then spill over to the kids or whatever our strategy is, execute powers of attorney. I'm sure people have used powers of attorney in your practice quite a bit as well, Mark.
Well, I'll tell you, my firsthand knowledge was, my wife and I, of course, we had them done just in case when we bought our home, one of us couldn't make settlement because of our schedules. So we made sure that everybody, that the powers that be at that table knew that I had power to sign for her and she had power to sign for me, just in case. Because when everybody gets to the table for settlement, something always comes up. That's Murphy's Law, right?
Right.
So that's where me. I'm only 43, but at the time, I was 33. We got powers of attorney. That's where I got my first-hand knowledge of them. But you're right; they could be as broad as you want. They could be as laundry list as you want, or they can just be for, I'm going to be traveling. I want her to pay my cable bill, my gas bill, my electric bill. That's it.
Yeah, and I recommend that husbands and wives have them. I recommend that people who are of advanced age, if they have a particular favorite caregiver or someone, consider giving them one. But of course, that's always fraught with the possibility that nephew could run off with all the family heirlooms or the estate or whatever. We see some abuse of powers of attorney. So it's a case-by-case basis, and I'm always a little leery when the young person comes in seeking the power of attorney, not the elderly person. That's right.
And just so the viewer, the listeners, I cannot serve as a power of attorney for my clients. I cannot, because I can handle investments. But Carl, I believe you can. Can you serve as?
Yes, and I'm an attorney at law. A power of attorney is an attorney at fact, and so yes, I can be both. Although I need separate documents to be your attorney in fact.
And that would probably be my suggestion. That if for any reason you hesitate on having the son or daughter be the power for those folks who are thinking about getting one, having their kids, and there's even that little pause, that little voice inside your head. And it's okay. I would look to a lawyer like Carl, or possibly even an institution like a bank or what have you.
Yeah, and of course the only caveat is that ends up costing a bit more money. But if it's the difference between being looted and spending a few dollars, it might make more sense. On the turn to the living will for a second. Yeah. That's your advanced life care directive, and to me that's a very important document. When a person is terminally ill or needs serious medical attention, there sometimes can be a breakdown amongst the next of kin as to what's the right course of action. Did Grandma want a feeding tube or not want a feeding tube? Did Dad want a respirator or not want a respirator? And that can lead to monumental battles. And if you have a particular belief yourself and you want it to be honored, you've got to lay it out. Otherwise, they are going to use every known form of advanced life care on you.
Yeah, in the Terry Schiavo case is well, that was the one that hit the media and everybody saw.
Perfect example, because it pitted one side of the family against the other side. The husband didn't think she wanted to be cared for. The family thought she did. There was the issue of a life insurance policy and a lot of recriminations. And really, if she'd have just had an advanced life care directive, it would have solved all that problem. And you could think that family would probably still be an intact family.
Yeah.
So it's a crucially important. And then you also can, as part of that, do a medical power of attorney where you designate who can make your medical decisions for you. Much like a regular power of attorney, a medical one speaks to just medical issues. So you could, for instance, if you don't trust your nephew with your pocketbook, but you would trust them with your medical care, you could give them just a limited medical power of attorney as part of the Advanced Life Care Directive. Of course, those can be done separately as well, and there is a standard form. So I always think it's very important that people consider that, and number one, so that what they want is done, but number two, so that everybody else knows. I literally drove out to a woman's house to write one of these one time. precisely because she already sensed that her kids were feuding. She was terminally ill, and they were already starting to argue over her care, and she was acutely aware of that, and knew that whichever side of the kids prevailed, the other side would, of course, think that what she wanted wasn't being done. So she had me write very clearly what she wanted done and exactly how she wanted it done, so that everybody in the family knew it was her choice, not one of the kids' decision to anger of anybody else.
Well, I mean, this has been a great podcast, and one thing I'll tell folks, because we really didn't touch too much on Medicare and Medicaid, but to those who have the necessary means, and for those who have decent health, and you'd be surprised what long-term care insurance can do for folks. That is insurance product, but for those who don't have the money to do life insurance and long-term care insurance with the premiums and what have you, there does exist. The insurance industry has responded, and they actually have products where it's a life insurance policy with a long-term care insurance rider.
Right.
Very unique vehicle. So, you just need to get to a professional, whoever that might be. If you have somebody now, great. Carl and I are not looking to interrupt any relationships you already have. However, we're just trying to make sure that you seek out the right professionals for the issues you have. Health care, power of attorney, as he said, or the living will, what have you. Here you are doing all these things to get your house in order to make everything as easy as possible for your loved ones. Why not do that last part on the health care side? That's a very difficult decision for husbands, wives, and family members to make.
And that's the other thing. There are a lot of complicated things you can do to try to avoid having Medicare eat up an estate, but long-term care insurance is a relatively simple one.
Just transfer the risk. That's all you're doing is you're transferring the risk if in case you do need help, or you have to go to a home, or you need someone to come in your house. Because I'm sure your husband, I'm sure your wife loves you to death, and they're gonna do whatever they can for you. But at some point, a wife can't lift a 200-pound man in and out of the bathtub or out of the shower.
Right.
I mean, you need someone to come in to make the meals, to clean the house, and do different things, as well as someone to come in for a couple of weeks and give you a break, what they call respite care. Let you just take some time off and get your sanity back together.
And Mark, I know that, I'll give you an example. If somebody has $100,000 in wealth, that's probably not going to be enough money to do a lot of esoteric, trusts and irrevocable trusts, because there's some risk in tying assets up that way, just as there is in the possibility of losing them. So then you run into, the question of, how much wealth should I have before I might want to self-insure? And the answer is, I think the average person's level of wealth, when I say average, meaning anybody with enough money that they're interested in what we're talking about, is probably should consider long-term care insurance as one of the pillars of their long-term strategy.
Right. And I would say the majority of my clients who have a lot of money, they look at long-term care insurance as something we talked about earlier, keeping their life private. They go to a nursing home. Here's my insurance card. Deal with them.
Right.
You don't need to know how much money I have. You don't need to know what stocks I have. You don't need to know anything else. Here's the card. Call them. They'll take care of my bill.
Mark, I want to thank you for being on today. We're running out of time, and if people want to get a hold of us, obviously they can get through me through weekendappointment.com, post their questions there, and I'll answer them. They can also find my contact information. I've posted yours on there as well, but can you just give us your phone number and website real quick before we go here?
Sure. Phone number 717, of course, 509-4521, or they can just call you, and I'm sure your office can throw them over to me. My website is Mirus, M-I-R-U-S, like miracle, mirusfinancialpartners.com.
All right, Mark, you've been listening to Carl Rominger and Mark Virginis on Weekend Appointment. Take care, folks.